Hello, students, and welcome to Lecture 6 from Week 3. We're going to continue our discussion of contracts. Let's talk about, and again, we go through this very quickly, and I just want to hit the highlights and would ask you to read through these and then also supplement with the text where it's confusing or not fully understood. Let's talk about defenses to the enforcement of a contract. In other words, you're trying to get a contract set aside or bring up a reason why it should not be enforced against you. Well, here are some examples. A lack of voluntary consent. Remember, we had offer, acceptance, and consideration for a valid contract. So when was there really not a valid voluntary consent? Well, in other words, a true acceptance is the best way, I think, to look at that. When there really wasn't acceptance because you didn't voluntarily consent to the contract. Number one, you made a mistake. Number two, the other party made a fraudulent misrepresentation. We'll get into that in a minute. There was undue influence on you. You're in a nursing home, and they said, if you want your medication, you're going to sell me that diamond ring for $5. Or you're under duress. I guess duress would be better at the nursing home. And undue influence might be your parent or a teacher or when you're younger, or someone that has influence on you that exercised in an improper way. There are different kinds of mistake, but the ones, so let's talk about different kinds of mistake. Again, we're talking about ways to essentially get a contract set aside and say it's not a valid contract. Mistake of fact. A mistake of fact makes a contract voidable. That is, it's not automatically void. You'd have to go to the court and argue that the court should void it or set it aside. Well, first, the fact at issue must be material. That is, let me give you an example. I'm going to sell you a car, and in it I say, gee, it has this engine, it has this performance, it has this many miles, it has, and an air freshener hanging from the mirror. Well, I don't know if a court would really consider a material item a 99-cent air freshener, but if you misrepresented or I misunderstood the horsepower, the mileage on the car example, the price, well, those would certainly be material facts. In other words, they're important facts. Unilateral, let's say that only I misunderstood what you were saying when you sold the car. Well, if both of us misunderstood, we both had a mistake of fact, then usually, court of course can set it aside because we both misunderstood. But if only one of us had a mistake of fact, that doesn't automatically allow you to set it aside. Rather, the contract can be enforceable unless the other party knew or should have known a mistake of fact was made. For example, you're selling me your car. Let's say I don't know how to drive a manual. You knew I don't know how to drive a manual. We've known each other for years. You sell me your car. It's a manual shift, not automatic. Well, you probably should have known that I made a mistake assuming that it was automatic. If you didn't know me, then there probably was no way for you to have known that I assumed it was not automatic. So those are two entirely different ways the court could rule or interpret the mistake. One, they might set it aside, another way they wouldn't. Let's move on to bilateral, when both of us make a mistake about the contract. We have the right to rescind or pull the contract back, make it ineffective, but we don't have to. We could still go through if we both decided to do so. Here you can see that it has to be material facts of this Exhibit 15.1, Slide 8. Bilateral, both of us, it can be rescinded. If it's only one of us, it's enforceable unless and you see the two times in which the judge can set aside the contract. Fraudulent misrepresentation, when you misrepresented a material fact. So let's say, for example, you tell me that the car you're trying to sell me has 20,000 miles on it, but really it has 120,000 on it. Well, then obviously that would be, I didn't consent to buying a car with 120,000 miles. I consented to buying a car with 20,000. So that would be a fraudulent misrepresentation on your part that would permit me to have the judge to set it aside. You can see, I'll let you read through, but these are the elements of what a fraudulent misrepresentation is. And I have to show that your conduct, you took an action to conceal it, you should have concealed it, or you should have disclosed it, etc. Again, we said earlier, statements of opinion, that's just a, hey, this is the best darn car ever. That is just an opinion. That's not a statement of fact. So a judge can't rely upon that to set aside a contract. Now, if you, let's say, for example, that I don't even hardly know anything about cars, and I buy a car from you and you give me an opinion, this is the fastest car on the road, or this will get you there in, you know, such and such time. Well, if theoretically, if I'm naive enough, then your statement of opinion, if I'm relying on your expert opinion, that becomes a statement of fact. Now, misrepresentation of law, you know, that's not usually an excuse, because unless, like, I'm a lawyer or a judge, you have as much duty to know the law as I do, or both of us could be considered equally ignorant of it. Now, a lot of times misrepresentation by silence doesn't occur, like I just kind of didn't say anything, but there are exceptions to that. I'll give you an example. Hey, I'm going to sell you the house, my house, but oh, by the way, it's infested with termites and it's about to fall down, but you can't see it because I painted over it. Well, that's obviously a silence that really is fraud, because I didn't tell you about it. You know, long ago, the churches would talk about their sins of commission and omission. Well, commission was when you overtly did something wrong. So if I fraudulently misrepresent something, that's my commission. I overtly told you. But the sin of omission, if you will, is I leave this out. Oh, well, but I should have told you. So that's what we talk about, misrepresentation by silence. So let me let you watch this YouTube video, hypertext link on slide 16. Welcome back. Intent to deceive. I'm going to have you go to 19 and then watch that video, because that does a better job than the text and these outlines in describing the intent to deceive. Now we're talking about innocent misrepresentation. If I say something about my house that I didn't intend to misrepresent to you, usually, and again, I almost always say usually, because there's exceptions to almost any rule that we can learn in the law. But usually a judge will let us set aside the house contract. In other words, you don't have to buy it, but then he's going to give you damages because I didn't intend to deceive you, for example. All right, I'm going to let you read through all the other scenarios or requirements of the reliance on the misrepresentation. Now, undue influence, we kind of talked about it, and that's a relationship which one party has so much influence over you that you just, it's almost like you don't have free will. So how could you really agree to something? Some might argue a parent. You become a K-pop star at 14 and your mom has a contract with you. She's the agent. She gets 90% of everything you make. Well, a court would look at it and say, wait a minute, that's not fair. It's not we're going to set it aside because that's undue influence that you had over her. So that you, Kate Pop Star, when you turned 18, could go to court, or even before then, could go to court and say, I really didn't give consent to that contract, so it is voidable. Judge, please set it aside. Let me let you look at some examples of duress and undue influence. Slide 27. Please look at, on slide 27, please look at those two YouTubes of the hypertext. Adhesion contract. Here's a good one. Just about every time that you, as a student, lease an apartment, it's sort of an adhesion contract. I mean, it's take it or leave it. The landlord is not going to negotiate the lease with you. When you buy a car, it's take it or leave it. When you get a bank loan for a car, it's take it or leave it. Well, often the court will say, yes, you agreed to all these terms within that adhesion contract, but if you can go to the judge and say, that is so unconscionable, it is so unfair, and it benefits the other side of the contract so much, then there's a chance that the judge will set it aside as unconscionable. Let me let you look at this video having to do with unconscionability on Hypertext Link on 31. Okay. 32 does a fairly good job of summarizing and putting in a graph, if you will, for you of instances in which there's not really voluntary consent, which I think is another way of saying I really didn't accept the contract because of these various factors that existed. Okay, chapter 16, you know, must contracts be in writing? Well, it depends. There's a thing called statute of frauds, and it basically shows that the law requires certain types of contracts to be in writing. Most do not have to be in writing. Please watch that video. It's on 34. All right, now that you're back, the reason we have the statute of frauds is to protect people. So someone just has come up and say, well, they agreed to do such and such. Well, where is it? Is it in writing? Here's the list, which you saw from the video. If it's the sale of land, it has to be in writing. When I say in writing, that can be digital as well sometimes, depending on the country and the state. But to sell land, if it can't be performed within 1 year, in other words, I'm going to paint your house 2 years from now, that has to be in writing. I can't enforce it against you because it's more than a year from now. Interesting, this is an old one. Process made consideration of marriage, so that goes way back in the old history. Or contracts for sale of goods priced at $500 or more. So any merchant, any company that's worth their salt, if they're selling you something for more than $500, it's going to be in writing, even if that's a sales receipt or you just signing a credit card statement. We saw the land, 1 year rule. I'll let you read through these and the collateral promise rule. I'm going to let you read through these on your own because I think they're self-explanatory. Certain exceptions to the writing. In other words, the court could say, yeah, usually such and such type of contract has to be in writing. However, in this instance, I'm not going to require the writing. One of those instances, or one of those becauses or exceptions for the judge is because somebody's already started performing the contract. So you can't, the paint, for example, you can't say, no, it was going to be over the course of 2 years. Well, if someone started painting it, the person supposed to pay for the painting can't say, hey, I'm pulling out because it wasn't in writing. Well, the judge says, no, it's the performance of the contract has been ongoing. Another exception is, gee, the sale of land or something had to be in writing. Then when we get to court, you show an email, or I on the stand admit, yeah, I agreed to sell the land to you for X number of dollars. So that's an admission I've made. So the judge might not require it to be in writing, that contract, and would enforce it. We've already talked about promissory estoppel in the other contexts. Here's again the UCC, or excuse me, the statute of frauds. That's a good outline, if you will, in a graphic form. All right, let's keep going. What a writing is, I'm gonna let you go through those on your own. And again, parole evidence. In a previous week, we talked about when can a court, when a court is interpreting a contract, when can the judge look outside of the contract and say, okay, I'll consider this outside the writing, the parole evidence. And if we can't do parole evidence, that means, boy, we don't get into our negotiations, we don't get into prior agreements, we don't get into oral agreements. What's on the paper is what's on the paper. That's the contract, nothing else. The exceptions, as we've seen, to the parole evidence is you say, well, wait a minute, Judge, yes, you have this contract in front of you, but we superseded that one with another contract. So you said you'd paint my house for $500, and then so I say, hey, you have to paint the house and the garage for $500. When you showed up with your van, you said, wait a minute, there's a garage also, it's going to be $550. Well, if I signed another contract saying, okay, it's going to be $550 for the house and the garage, you can see the contract was modified. So even though it's outside of the contract we're talking about, the $500 contract, you can still bring the $550 and judge, we came to a new agreement. So look at this. You can also look at parole evidence on voidable or void contracts. So for example, if in writing, I forced you to sell me your diamond ring for $5, if you're arguing that's voidable or void, then you can bring in evidence. Hey, I was in the nursing home, or he's my dad, or blah, blah, blah. And the judge, in other words, the judge can look at something outside of or other than just a contract. Ambiguous terms, the judge can have to look outside the contract because it's ambiguous. So we have, what did the parties mean? Let's take some testimony. What did they write letters to each other saying this is what they understood that to mean, et cetera, et cetera. The complete contract, same thing. Yeah, there's a contract, but it really doesn't address everything in the transaction. The judge also at times may look at, gee, I, Kevin, have a business and you've been selling me parts for the things that I manufacture for 20 years. And we're arguing over a contract in year 20. Well, the judge might look back and say, over the last 20 years, this is how they've done it. So this is how I'm going to interpret the contract. You can see the other issues. Integrated contract, that simply means next time you sign a contract, a lease, a loan, or something, there will probably be a paragraph, a provision, if you will, sentence or sentences that said, hey, this contract is the final contract. It supersedes and integrates everything we've talked about up to this time. That's all they're talking about when they say integrated contracts. This has everything in it that we now agree on. So, you know, don't go back and look at our negotiations, don't look at our things. This is the contract. All right, there is I have been involved in international business for 30 years, and you know, I often argue there is no such thing as just domestic business. I mean, almost no matter how small you are, you're buying something or selling something internationally, or a part came internationally. So just an FYI, there's a thing called the Convention on Contracts for International Sale of Goods. And that basically says if you, the buyer and seller, haven't said what country's law applies, then a convention is similar to a treaty. This convention applies, and basically it's the Uniform Commercial Code, which had all these laws you might remember on how to interpret contracts. Its Uniform Commercial Code is only the U.S., so this is actually the equivalent in international sales. So if your country is one that signed off on this convention or treaty, then this will apply if you haven't otherwise said it doesn't apply or if something is missing. All right, now, breach of contract. Okay, well, you breached the contract, or I breached the contract. What are we going to do about it? Well, that's called the remedy, okay? So, for example, you hit me, let's forget contracts for a minute. I run into you with my car because I'm looking at my phone. Well, we'll go to court. The court basically will look at two things. Number one, liability. And the court can say, oh, Kevin's liable because he was looking down at his phone. But then the second question is, okay, now what? And then what is your remedy? What's the judge going to do about it? Well, he's going to make me pay your medical bills and your out of work costs and et cetera, rent, whatever, et cetera. That's the remedy. So if you and I have a contract, whoever has broken the contract or breached the contract, breached is just another word for broken when it comes to the contract. If whoever has breached the contract, the other party can ask for one of four things usually. I want money, I want rescission, we'll declare it never in existence. I want you, judge, to force specific performance. In other words, they have to do it. Or judge, I want you to reform or essentially rewrite the contract to make it fair. Let's look at each of those. There are generally four types of damages in contract law. One is compensatory, and that's, for example, it covers my direct losses. Gee, I didn't, you were going to sell me your car for $10,000. I was going to sell it for $12,000. I lost $2,000. Or you were going to supply me with the metal parts, and I, in turn, was going to make cars and sell them. Well, I've got damage. I wasn't able to sell cars because you get me the metal parts in time. Consequential it's even beyond those direct losses. And we'll get into that a little lower down here. Punitive is generally, and again, I have to say generally because there's an exception to almost every rule. Generally, punitive damages aren't available in contract law, but as you'll see in the future, they're available in tort law. And that's basically to punish the wrongdoer. And then nominal. There's been court cases where somebody sues another one for defamation or, gee, you said something about the newspaper, but they can't prove that they were really damaged by what was said in the newspaper. So the judge will say, okay, you win. The person you said something about, you're suing the newspaper, but I'm going to give you $1 in damages because you haven't really proven that you were harmed. You haven't proven your damages or any monetary loss. Compensatory, you'll see this. What's the loss of the bargain? How was I wrong? And basically, it's a pretty simple mathematical formula. What was promised? The person that breached contract, they promised they'd do X. They didn't do X. So what did they do? And it's a mathematical measure. Compensatory, it's incidental. What's caused by it? For example, difference between the contract and the market price. You were going to sell me these metal parts for $10 a piece. When you didn't, I had to go buy them from somebody else for $12 a piece. So my damages aren't $12. My damages are the $2 difference. Let me say that again. I'm buying, promised to sell me parts for $10 a piece, but you didn't do it. I had to go out and buy them for $12. I had to pay an extra $2. I would have paid $10 no matter what, but it cost me an extra $2 a part. So that's the difference between the contract price and what I had to go out to the market and pay a market price. Compensatory damages, I'll let you look at the things that a judge can order for construction contracts. Here's a nice measurement of damages graphic for you on construction, for example. All right, consequential. These are sometimes called special damages, foreseeable damages. So even though it wasn't the direct loss, even if it wasn't the $12 that we saw, you, when you breached the contract, should have known that I was going to have that loss. For example, I wasn't able to sell cars to anybody, so it wasn't just a $12 part. I lost a $20,000 sale of this car, okay? Punitive, you know, a judge or jury can do it to punish somebody. A good example is like an insurance company, pharmaceutical company comes up with a drug. They don't test it well enough, or the opioid crisis that we just saw. They really advertise or push these painkillers, and some people end up killing themselves. Well, a jury or judge can look at how much money that pharmaceutical company's worth and say, gee, this individual person was only damaged $10,000 in medical fees, but we want to punish the pharmaceutical company. They're worth $1 billion. We're going to award $100 million. Now, you're not going to be tested this, but there's a moral and political and philosophical and sociological issue there. Is it really the right thing to do to assess $100 million against them, where one person is going to get $100 million for $10,000 damage and everybody else doesn't? I mean, some judges address that public policy issue by saying, okay, we'll assess $100 million, but it's going in a fund. They have to set up a trust, and then whoever is harmed in the future and past can come and seek part of those funds. We already talked about nominal. Now, let's say, for example, you didn't sell those parts. So can I just turn around and say, hey, I didn't sell $25,000 cars, and there's 100 of them, so you owe me, $2.5 million or whatever the math is. Well, I had a duty, as I'm not the party that breached. You're the party that breached or broke the contract. You didn't sell me parts like you agreed in a contract. Well, I have a duty to try to minimize, in other words, mitigate the monetary loss to myself. So if I can turn around and go buy $12 parts to the $10 you agreed but didn't deliver, I have a duty to do that, instead of just not throwing up my hands and then trying to sue you for millions. So party that's injured has a duty to try to mitigate damages. The trick, if the landlord, you default on your rent and go out, and the landlord has an acceleration clause, some might argue and says, oh, well, you owe me for a whole year's rent. Some might argue that no, you have a duty to try to re-rent it, landlord, and if you do, and you're not lost any money, then I don't owe you for an entire year. I'll let you read through the mitigation of damages. Liquidated versus penalties. Often in our commercial contracts, you're selling me the parts, for example, we'll have a contract between we two companies. Well, there's often a liquidated damages provision where we'll say, gee, it's hard for us to really estimate what the damages will be going forward. For example, I sell cars. You could damage if you don't give me these parts sometime, you could damage my reputation. And in the public media, New York Times might say, I don't deliver cars when I said I would, or da-da-da-da. Well, that could be millions or billions. Well, in those instances, sometimes we'll put in what's called liquidated damages. We'll say, all right, for every day that you don't deliver, you have to pay me 1% of the contract price. So you pay me 1% of the $12 part for every day you don't deliver it. If you go 100 days, it's, you owe me 100% of that value. So that's what's a liquidated damage. It simply means agreed. We've reduced it to an agreed amount. That's to be distinguished from a penalty. Some companies with whom you deal will have contracts in there that would be construed as a penalty, and it's not fair for you to have to do it, even though they call it liquidated. If it's punitive, if it's a penalty, then it won't be enforced by the court. let you read through that. Okay, Judge, let's say that I'm not coming to you and asking for you to give me damages, all right, or money. Rather, I want rescission. So in other words, you didn't deliver me the contract. I'm not seeking money, but Judge, I want you to give me a judicial order that says, okay, the contract's set aside. That's a rescission. So the judge is able to do that, saying, okay, I mean, let's say, for example, I entered a contract that you'd provide me these parts for the next 5 years. The first 3 months, you don't provide me any parts. I could go to the judge and say, yes, I agreed to buy for X number of years, next 5 years, but they didn't deliver them on time. Please set the contract aside, and the judge may well set aside the contract, a rescission. Restitution, sometimes we'll just say, okay, we're going to hand things back to you. I traded you this car for your motorcycle. I might go to the judge and say, look, I'm not asking for money. Let's just give each other, I get the car back, you get your motorcycle back. That's a restitution. The judge could order that. Now, specific performance is when a judge, for example, might order the breaching party. Let's say, for example, you had a piece of land, including mineral rights and everything, and you offered to sell it for me for, $10,000. It's an acre. Well, let's say after we signed the written contract, the next day you found out there's oil on it. And you say, geez, I'm not going to sell it to him. It's worth $10,000 for me not to sell it and drill the oil. Well, the judge, I could actually go to the judge and say, force him to sell it to me for the $10,000, and the judge may well do it. Also, contracts for personal services, for example, if I'm a famous painter, the judge might come in and force, me to actually do those services as agreed. Reformation, the judge sometimes has latitude to change or modify the contract. It's unfair, it's inequitable. Instead of just setting aside, he might be able to say, you know what, I'm going to take a pencil and I'm going to change this, or I'm going to get on the computer and I'm going to edit this. And so this is what the contract fairly should say. So there could be a reformation of your contract. Covenants not to compete. Here's just an interesting note. Sometimes if you guys look at your employment contracts and they might have covenants not to compete, I won't go out to a competing business, for 5 years after I quit. Well, just FYI, in Oklahoma, that's largely unenforceable because we actually have a constitution and a statute that prohibits it. But a judge might say, well, you can have them not compete for a year, but 5 years is not reasonable. Or they can compete on the East Coast, but not in Oklahoma. So a judge might reform or revise, in other words, the contract language to make it enforceable. We did talk about quasi-contracts already. I'm going to let you read through that. Waiver, you might have a contractual right, but then you might agree not to enforce it. You don't enforce it, you don't do it. That's known as a waiver, okay? And if you voluntarily and knowingly waive your contract right, then you can't later argue that, that, oh, gee, was the breach. I'll let you read through waiver. Let's see. Exculpatory clauses, I like those because think about driving behind a gravel truck. There's so many trucks on the highway. Instead of the surface roads, why can't they just go on the surface roads on the highway where they're gravel and dirt and sand is coming out and cracking our windshields? And then there's a sign on the back that says not responsible for damage. Well, that's just not true. Let me give you an example. If I put a sign up on my front lawn and said not responsible for injury if you step on my lawn. You step on my lawn and I run out and hit you with a hammer. Just because I have a sign up doesn't mean that I'm not responsible. That exculpatory clause, they're often just absolutely unenforceable. Limitation liability, those are, you have to look at it on a case-by-case basis, look at the facts. So for example, I can't just have, gee, you can't sue me for my fraud, my intentional injury, my illegal acts, etc. Okay, that's all for this week. If you have questions, make sure you refer to the text.